Hello, everyone. Welcome to Law for Palestine's session, Deciphering the ICJ hearing on South Africa versus Israel, Arguments and Prospects. South Africa has taken Israel to court for the first time in history. South Africa's Justice Minister, Ronald Lamola, opened his remarks with Nelson Mandela's words, "In extending our hands across the miles to the people of Palestine, we do so in the full knowledge that we are part of a humanity that is at one." We witness South Africa living by Mandela's words, extending its hand and standing up for Palestinians in its ICJ application for provisional measures to halt Israel's genocidal campaign. It does so to assert both an individual and a collective right, the Palestinians' right to exist and a common right to humanity. We are witnessing a historical moment that has direct repercussions on the situation on the ground. Today, we gather to decipher these repercussions, exploring key arguments and counter-arguments, and discussing the prospects of the provisional measures application and the case. We are humbly joined by three leading legal scholars and lawyers in the field: Dr. Ralph Wilde, Professor John Quigley, and Diana Buttu. We have around an hour and 15 minutes, and if needed, we can extend depending on the availability of our guests' time. For a bit of structure, we'll begin our session with our speakers giving their general remarks for around 5 minutes each, and then we'll proceed to a round of questions to each of our guests that we would appreciate their insight on. To introduce our speakers, I'm going to start with Professor John Quigley. He's the Professor Emeritus at the Moritz College of Law at the Ohio State University. He's an expert in international law, human rights, the United Nations, war and peace, East European law, African law, the Middle East, basically the legal encyclopedia we all wish we had. He appeared before numerous tribunals, and related to our discussion today, he was the advocate and counsel to the government of Bosnia and Herzegovina in its case before the ICJ concerning the application of the Genocide Convention against Serbia in 1993. Our next speaker, Diana Buttu, is a lawyer, analyst, writer specializing in negotiations, international law, international humanitarian law. She wears many hats and brings a wealth of expertise to our discussion today. Earlier in her career, Buttu took part in the Israeli-Palestinian negotiations, serving as the only female negotiator during her 5-year tenure. She also played a pivotal role in the ICJ advisory opinion on the illegality of the apartheid wall in 2004. She also served as the former advisor to the Palestinian president and prime minister. And last but not least, Dr. Ralph Wilde is an associate professor in the Faculty of Law at University College London. He's an eminent expert in international law with a focus on colonialism, self-determination, occupation, use of force, international humanitarian law, and the list goes on. Dr. Wilde has been a consultant to several bodies and served on the executive boards of the American and European Societies of International Law, as well as the International Law Association. Dr. Wilde currently serves as the legal representative of the League of Arab States in the ICJ advisory opinion on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territories, including East Jerusalem. He joins us today in his individual personal capacity. It's truly an honor to have all of you with us today, and I'm super excited for today's discussion. Hopefully, a lot of insight and fruitful debate or conversation. Now, I know that Professor John Quigley won't be able to stay throughout the entire session as he has another commitment to get to. So if Diana and Dr. Wilde don't mind, I would like to start with Professor Quigley's general remarks and then pose a question to him before he leaves us. Then I'll come back to hear Diana and Dr. Wilde's remarks and proceed to our round of questions for the day. This session is designed to be a casual chat, so please feel free to jump in, offer your take on the proceedings, ask questions of each other. But for now, my opening question to all of our guests. Yesterday, we observed South Africa's oral arguments where it built upon a comprehensive 84-page application. It meticulously cited evidence from the UN and allied sources highlighting an unprecedented amount of genocidal intent publicly stated by Israeli officials. South Africa has formally requested provisional measures from the ICJ, including an immediate suspension of Israel's military operation in and against Gaza. Today, Israel responded to South Africa's arguments, contending that the court lacks jurisdiction due to the absence of a dispute and the lack of plausible rights to be protected. Israel asserted that the situation in question falls under international humanitarian law and not the Genocide Convention. It argued that the standards of irreparable harm and urgency, which are required for provisional measures, are not met. Israel maintained that each provisional measure is unwarranted and prejudicial. Professor Quigley, what do you make of this?
Well, I think on these actually 3 points that you've mentioned, I don't think Israel helped itself very much. On the issue of suspension, it cited some other genocide cases where the court has given provisional measures, but did not satisfy a request to end the military action entirely. In our situation, it's a bit different because, as was argued by the Republic of South Africa, the suspension of the military action is necessary to put an end to the ongoing genocide because of the fact that the population has nowhere else to go and is not able to get aid so long as the bombing is going on and Israeli soldiers are on the site. So those prior cases that were cited by Israel are really not pertinent to the current situation. On the question of dispute, Professor Dugard had argued quite nicely that there is a dispute and that there is no obligation to negotiate. And that is accurate in terms of Article 9 of the Genocide Convention, which explains the circumstances under which the court would have jurisdiction over a dispute. And the Israeli lawyer, this was Malcolm Shah, said that Israel had offered to negotiate, but as Professor Dugard had explained, negotiation isn't necessary. Professor Shah was trying to say that since Israel was offering to negotiate, that meant there wasn't yet a dispute, but that's a different matter. So I think Israel will not succeed on that point. The question of intent to genocide, I think it's the circumstances that are the strongest indication here. The representatives of Israel focused on the statements that appear to be genocidal made by Mr. Netanyahu and others, and attempted to explain those away. But even if you can explain them away, I think he said they were, well, there was one of the lawyers said that these were statements by some politicians, I think was the way he put it. Of course, one of them is the prime minister, and they're rather chilling statements. But even if you explain them away, I don't think that gets around the fact that an evacuation order was given on the 13th of October under circumstances where it was obvious that people were going to die as a result of that order. So when you put those statements together with the situation and with what Israel did, I think that makes for a strong argument for intent. The court in the past has not analyzed the question of intent very well in genocide. I think in further proceedings, it's probably going to be a good idea for South Africa to go into that more than it did. In the application, South Africa said that the situation shows the requisite specific intent on the part of Israel. The word specific does not appear in the Genocide Convention. It does appear in case law. So the South African application was taking that term from the case law of the court, but not from the Genocide Convention itself. And when you look at the court's prior rulings, they came up with this word specific out of nowhere. I mean, they really have no basis for it. So I would like to see South Africa challenging the court more on the legal definition of intent, because that makes it even more clear that whatever reasons Israel may give will not negate the intent required for genocide.
Thank you so much for that insight. And I completely agree in terms of, first of all, the cases that Israel tried to draw parallels with as precedents for not issuing provisional measures are not comparable to our current circumstance. And rather, South Africa highlighted yesterday that the cases, especially those that were concerning the Genocide Convention, whether it was Bosnia, Serbia, Gambia, Myanmar, Ukraine, Russia, the court did order provisional measures. Now, my question to you is, South Africa emphasized yesterday, and I quote, that it would be a complete departure from the long line of jurisprudence that this court has firmly established and recently reconfirmed for the court not to order provisional measures in this case. Do you believe that the ICJ may break its stance with its jurisprudence? Can we expect that move?
I think it's more likely that the court will stay with its jurisprudence. I think it would be unlikely for the court to impose a higher standard here than it did in the Myanmar case. In the Myanmar case, there was probably less evidence of a dispute between Gambia and Myanmar than we have of a dispute between South Africa and Israel in this case. And that, of course, is one of the underlying questions that South Africa has to show that there is at least plausibly a dispute. So I would expect the court to stay with its own jurisprudence.
Thank you. Also on the jurisdiction aspect, Israel argued that the court must balance its rights against the risk of irreparable prejudice. And we know that the UN General Assembly and the majority of the UN Security Council found that a bilateral ceasefire strikes the right balance. How can the court find a way to achieve that despite lacking jurisdiction over Hamas? And would it be sufficient if Hamas releases a statement indicating compliance with the court order?
Well, I think the question for the court is simply what Israel is doing. I think the court is not going to want to begin to think about Hamas and what it might do, whether it would suspend operations. I think if the court decides that the suspension of operations by Israel is necessary in order to stop the genocide, I think it will go ahead and do that and will not inquire into what Hamas might or might not do.
Got you. Thank you for that. And my final question, would the court ask for further submissions and details from the parties? Would any of them be able to make new submissions for this provisional measures?
That's a very interesting question. I mean, so far each party has given a written statement to the court. There isn't a specific provision for it in the court's rules, but I think it would be permissible to do that. The problem is it would have to be done very, very fast because the court is beginning right now to think about what it's going to do. So that from the practical standpoint, that makes it difficult to make any additional filing. It could probably be done as an amendment to the application from the side of South Africa if they want to do that.
Got you. And a quick follow-up question. What is the timeline that we're looking at? In prior precedents, what have we seen, what speed have we seen the court work with in terms of a provisional measure application?
Well, it's usually been about 2 or 3 weeks. Now, the 4 of the current judges will no longer be judges as of the 6th of February. So I think the court certainly is going to want to have an order out before there's a change in the personnel of the court.
Thank you. I appreciate that. Diana, I will move to you. If you could please offer your general remarks on the past 2 days. And I just want to say that I follow you on Twitter. So you mentioned yesterday, you tweeted, or it's called X today, but you posted, "Thank you, South Africa." And as a Palestinian, I share that sentiment and also want to use this opportunity to say, thank you, South Africa. The floor is yours.
Thank you. Thank you, Dalal. Thank you for hosting this. And I really want to thank my 2 co-panelists who I haven't seen for such a long time, and I wish we could see each other much more frequently. Professor Quigley, who's always been a mentor, and Professor Wilde, thank you both for all that you do. Yes, thank you, South Africa. Thank you, South Africa. Look, I think stepping back, because I know this is a law panel, but I want to step back a little bit and talk as not just in a law panel, because law is not separate from society, as what it meant as a Palestinian. You know, there was something very powerful about watching this yesterday's hearing and hearing a representative of the South African government come forward and use within the first 5 or 10 seconds, talk about the Nakba, talk about what life has been like for Palestinians for the past 75 years, tie it to this military, 56 years of military occupation, tie it to the 17-year blockade on the Gaza Strip. And it was so powerful to see that. And it was so powerful that it was coming from South Africa, a country where there has been a long history of Palestinian, South African solidarity, of Palestine liberation, anti-apartheid activism for such a long time. And so seeing this all come at once was not only thank you, South Africa, but very, very, very uplifting and overwhelming. I, like you, Dalal, and others who are watching this, we've spent the past nearly 100 days hoping that, and in this crazy belief that it's going to be this picture that's going to change public opinion. No, it's going to be this video that's going to change public opinion. No, it's going to be this event that's going to change public opinion. And you live every day with this picture. It's going to be this picture, this video, this event. And it's been going on now for 100 days. And in those 100 days, we've you're torn apart because you're losing friends have been killed, maimed. I don't have a single friend who's still remained in their house in Gaza. Gaza City, as I once knew it, has been flattened. There isn't a single house left in Beit Hanun. And so what was incredible about yesterday's submission was that it was the first time, at least for me, that we had a chance to get this bird's eye view and to see what Israel has done over the course of nearly 100 days, and to see what Israel has gotten away with for nearly 100 days. So for me, it was incredibly emotional and moving, and I felt seen. I felt heard, which it's one thing to have global protests, and those protests have been so important and they're so uplifting, but it was just another level to see a state come forward and say, enough, not in our name. This is a question of global humanity that's at stake. And we're going to take the heat, knowing that South Africa is going to face repercussions. We all know it, from other countries around the world. So for me, it was incredibly moving. This is me speaking as the Palestinian. As a lawyer, also. Why? Because the arguments were tight. And as you know, all of us on this call know, you don't need to be a lawyer to know that what Israel's doing is wrong. You don't. You don't need to have gotten the JD or the LLB or whatever the initials are. You know what it's wrong. But to see it weave together in the language that others understand. It was a tight submission. I feel they really did a good job of not only making the case, but of demonstrating humanity, of tying it all in. And without the theatrics that the Israelis brought, it was a tight, well-written submission, and it was a tight, well-argued oral submission as well. And I was deeply, deeply, deeply moved. And it's not just me saying thank you, South Africa, and these Palestinians around the world. And I would hope others as well, too.
Thank you. Dr. Wilde, the floor is yours.
Well, thank you. It's a great pleasure and honor to be with you. And I have such deep respect for Law for Palestine. It's such a wonderful organization and initiative. So I want to pay tribute to you all, first of all, for this great organization, to the organizers of Law for Palestine. Thank you, Dalal, for bringing us together and chairing this event, and also to be able to pay tribute to the wonderful Deanna and John, two people who are real heroes of mine. And so to have the privilege of being on a panel with you is really quite something. So thank you for that. As was mentioned in the introduction, I have the great privilege and honor to be the legal representative of the League of Arab States in the other case that is before this court. As John mentioned, with a different composition on the bench that will take place between now and then, but the hearing will be in just over a month. So I'm very constrained in what I can say, and obviously everything that I say, I do so only in a personal, individual capacity, and nothing that I say here should be taken to reflect the views of any of the 22 members of the states members of the Arab League, or indeed the League itself. One thing, of course, coming into this particular case is the opportunity that it provided to address such a horrific, severe violation of international law in a way that the other case that will be back in The Hague next month is more general. And so but does include genocide. And so in some ways, what we saw today and yesterday is a sort of strange dress rehearsal for another event in the same building on the same issue, with not just one state pushing forward these challenges to the legality of Israel's behavior, but many states and international organizations. And South Africa has led the way, and South Africa may be back. The court hasn't published yet the list of the participants who will make the oral submissions next month. But presumably South Africa will be there again, along with many other states, most of whom and international organizations, most of whom will be there to support the case being put forward by Palestine itself. And this case will address the full spectrum of international law violations by Israel. When it comes, though, it seems potentially specific to 67 onwards, although not necessarily. And Diana, you mentioned the way that the South African submission yesterday opened with the reference to the Nakba, and it was, of course, I suppose inevitable that Malcolm Shaw then couldn't resist the temptation this morning to refer to the mandate being adopted by the League Council in 1922 and the Balfour Declaration of 1917, and then he went back even further, of course, in history. What's also striking is the difficulty of these cases and their supposed bounded focus. So this case is ostensibly only Gaza, ostensibly only since October, ostensibly only genocide. The advisory opinion is a much broader set of all areas of international law, but only ostensibly since 67, although one aspect of the question is potentially broader. In fact, it's just not possible to be so limited to address actually the specific questions before the court, right? So we saw today and yesterday that this case is about self-defense. And is there a right of self-defense? And is it applicable? Does Israel have a lawful right to use force in that context? That question cannot be answered from October onwards, legally. Because Israel's use of force, Israel's actions now are a continuation of its actions in the Palestinian Gaza Strip since 1967. And their legality, in terms of its existential legality, it's Israel's right to be there and the right to use military force, is a question of a continuing act that has changed over time in different forms, but has always been a use of force. So it's impossible to answer that question, even the narrow question put before the court. Self-defense or genocide, perhaps something that we're going to come back to in the discussion. Similarly, in the advisory opinion proceedings, and in this question, in the genocide case, the status of the territory and the implications that has for the legality of Israel's behavior will indeed require potentially consideration of the significance of the Balfour Declaration and the Palestine Mandate, but not, I would suggest, in a way that favors Israel, actually. But that's something that I can talk about if you'd like me to. But as some people have already said on X, and in fact, Malcolm Shaw has written an article about this in the Israel Law Review, which he's one of the proponents of an argument that I myself have provided the counter argument to when it comes to Balfour and the League mandate so-called agreement providing a legal basis for a Jewish state in the territory between the Jordan River and the Mediterranean Sea. It does not legally. And that may be then something that the court has to address next month, and maybe even in relation to this case. So this is my overall impression was how, in a way, what Diana mentioned about South Africa starting with the Nakba, it symbolized for me the impossibility of how these legal proceedings can keep the crucial questions out of the courtroom. They will come back in, they need to be addressed, they need to be acknowledged, not only politically, but actually also legally.
Wow, thank you so much. Thought-provoking remarks from both of you. I do have to say also, when the South African ambassador opened the session with his remarks, he spoke of everything as a continuum and brought in context and explicitly said an ongoing Nakba. And as Diana said, listening to everything being presented together, you get a sense of how much suffering Palestinians had to endure throughout these years and how much Israel has gotten away with. And speaking of impunity, Diana, I know you also tweeted and asserted in our discussion here that Israel cannot evade this time. And I want to unpack this a bit in terms of strategy. Bringing this case as a genocide case, knowing the high threshold for the crime of crimes, not to say that what we've witnessed in Gaza does not meet that threshold, but perhaps with the preview of the presented arguments and counter arguments, I'm not sure if we would have brought it as a case of crimes against humanities or war crimes. We would have ensured a favorable ruling and accountability. Do you believe that bringing it as a genocide also has, we're equally confident that we will get a favorable ruling, and this will be a moment of accountability in light of all those decades of impunity? And also, if you could speak to the interplay between all these different crimes and how ruling on one may affect another.
Sure. So the reason I mentioned that they can't evade it this time is, you'll recall in 2004, the reason that Israel was able to evade was for two reasons. One is that it was an advisory opinion. And as you know, advisory opinions are not the same as having a decision that's taken by the court in an actual dispute. And at the time, there was all this issue about jurisdiction, whether Palestine is a state, blah, 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 which we hopefully have gotten over. And so Israel was able to evade, one, because it was an advisory opinion, but two, and this is the part that's even more important, because even though in the advisory opinion, they say some pretty amazing things about the right of self-defense, the lack thereof. And they talk about the right, the responsibility of third states. So as you may know, or people who aren't maybe as versed in law may not know, usually if it's a dispute between two parties, it's those two parties that have a responsibility. But there are some issues where it's not just those two parties, but other states are also involved. And what was important about the ICJ ruling in 2004 was that it implicated and widened this scope of the responsibility of third states. Why am I saying that they were able to evade? Because we had both Israel evading because of it being an advisory opinion, and third states also evaded, again, because it was an advisory opinion. This time around, it's very different. And do I think that they did a good job, like strategically smart in bringing it as genocide? Yes, for a few reasons. One, because it is genocide. And because it's genocide, and the request for provisional measures just becomes that much more urgent. But then also because Israel's attempt to evade in 2004, as I said, was bolstered because third states also evaded. You can't do that when it comes to genocide. There's a general rule that all states have to come together and prevent genocide. It's not just Israel that has to stop it. It's the prevention of genocide. So I actually think that it was very clever that they did this as a request for provisional measures, and then B, using genocide. And I think that it also then, it's not going to bode well for Israel, because let's say that there is an order. Israel can try to evade it, but it's going to then require that resort to the Security Council. Maybe the US will veto. Maybe they'll do what they did this last time around and abstain. But what message is that saying? And then let's take it a level further. Even though the US may try to veto or abstain, you then have other individual states whose hands aren't going to be as tied. And this part is important, it's such a tragedy that's going to come after we've paid such a very heavy price, and we have paid a very heavy price. But this bolsters the BDS movement. When you see that Israel is not paying attention or is ignoring an ICJ ruling, when you see that it's either ignoring or having its mommy America veto a UN Security Council resolution or abstain from one, when you see that other states may be doing nothing, believe me, the world is going to act, and we've already seen them act in ways that have been incredible. And so this actually bolsters the BDS movement. So in sum total, I think it was very clever, very strategic. And again, and I share Professor Quigley's assessment. I might be being optimistic, but I share his assessment that I don't think that the court can really evade this. I don't think that they can try to turn this into an issue that they either don't decide or that they decide in Israel's favor. I just don't see it.
Thank you for that. I'm also a bit optimistic, but let's hope that turns into reality. The second half of the question, if you could elaborate on the interplay between all these different crimes, and if, for example, what does it mean to rule on genocide for the other crimes? Does that mean that we rule on genocide and it's the crime of crimes, and so the others don't come into play? Could you please elaborate on that?
I think we have to narrow things. So what they're talking about is only provisional measures. And I don't know if they're going to go forward with the full case, but it's not clear. And so because it's the issue of provisional measures, I think we should focus on that. What you're talking about is exactly what the Israelis were trying to do that today in their submission. You know, war is ugly, war isn't pleasant, and yes, there may be things that happen, but they don't rise to the level of genocide. That was the essence of their argument. Actually, the essence of their argument is war is ugly and leave us alone. But what's very interesting about this submission, and why I think we should just focus on what has been done in this submission, is that it's really just, it's the narrow. It's saying we see that we're on this path, and because we see that we're on this path, the court has to do something. And by the way, this speaks very tellingly to the issue of jurisdiction that the Israelis raised. If the court doesn't have jurisdiction, then quite frankly, who does? And that's the part where you can see that they were trying to play this like shell game, like it's not this, and it's not this, and it's not this, and this court doesn't have jurisdiction. Is it not a dispute? Well, then who is supposed to determine this? Isn't that precisely the role of the courts?
Yeah.
And so and then they did the same, like this isn't this might be a war crime, but not that. Like it was again this whole shell game that they were trying to play in order to distract. And that's why I think that we haven't gotten to this yet, but that's why I think the Israeli submission, oral submission, was actually very poorly done. It didn't come across as persuasive. It came across very insular. And to be honest, I felt like they were arguing the same way that they argued before the Israeli Supreme Court. But the Israeli Supreme Court, it's practically a guaranteed win because the state and the courts have an interest in continuing the occupation rather than ending it.
Thank you so much for that. Dr. Wilde, you brought up self-defense, and this was a much anticipated counter argument from Israel. And South Africa yesterday did its part in trying to refute it pre-head, and I think it did a very good job. However, I noticed about Israel's response today that it did not point or talk about Gaza's occupation. It never classified the conflict as international armed conflict or non-international armed conflict. It simply asserted that when a state is attacked, it has a right to defend itself without specifically mentioning Article 51 of the UN Charter. And indeed, it kept it broad, citing customary international law, UN Charter without specifically citing articles. It seems that it was skirting around the issue of occupation without addressing it. And it completely ignored the argument that there is no self-defense for occupying forces. I know you wrote about this extensively. I also follow your work. And you have a piece on a penal jurist that I recently read on how Israel's war in Gaza is not a valid act of self-defense in international law. I personally have always read that in the context of Article 51 of the UN Charter and the 2004 advisory opinions interpretation. But could you elaborate more on what do we make of Israel's response in keeping it vague and broad? And is there something else in customary international law that it can cite to assert that right?
Thank you. So I'm thinking in a way following on from what Diana said about how Israel made its arguments, because now Israel, I mean, if this goes to the full hearing, and they're avoiding this because they're not participating in the advisory opinion hearings, right? But if this goes to the full hearing, they're going to have to actually explain some quite fundamental things that they have sought to fudge and deliberately keep in a vague way that keeps their options open. So this made up category of disputed territories, for example, that they use, which is essentially a way of saying constructive ambiguity around the idea that perhaps Israel doesn't have sovereignty, but has a right to sovereignty over them, based on the Balfour Declaration and the Mandate Agreement, that kind of idea. And so I was getting those vibes today with these vague references to defense, self-defense, right? Which can mean all things to all people, right? I mean, Israel can take actions within the territorial Israel in a way that is defensive, right? That would have nothing to do with international law. It wouldn't deal with Article 51 of the UN Charter or customary international law or anything. I mean, so a state indeed would have a right within within international law to take action domestically within its own territory to defend itself. for example, in international human rights law. So all sorts of different and some mutually contradictory bases could be behind those statements. I thought they were, kept at the necessary level of vagueness and generality, so as to avoid Israel needing to be pinned down for any purpose, including this case, or indeed the advisory opinion case next month, or for any, or you name it, right? So self-defense is too vague. Like disputed territories is too vague. It's not a term of art in international law, unless you're talking about the right to use force in extraterritorially in self-defense pursuant to the right of self-defense in international law. But Israel didn't say that. As you said, Dalal, Israel didn't characterize Gaza as an occupied territory. It didn't characterize Gaza as extraterritorial to it. Didn't characterize it, obviously, as the territory of another state, or somehow a non-state self-determination unit that has sovereignty. So the position there is vague, and for what it's worth, to explain the position that I take, we go back to 67. The war in 67 was itself illegal, and even if it was lawful for the reasons that Israel said it was taking that action, which was defensive against the three states, the clue is in the name. It was over in 6 days, and Israel has a peace treaty with the two states that it captured the Gaza Strip and the West Bank from. It has a peace treaty with those two states. So manifestly, Israel is not in a state of war with those two states that it was at war with in 1967, that it captured the territories from. And what I think is often missed here is, which suits Israel, is that somehow many people disconnect an initial use of force with the military occupation that it enables, and somehow only do the analysis of legality at the initial capturing of territory stage, right? Was the 6-day war lawful, was it not? Without acknowledging also that then the occupation is a continuation of that use of force, and falls to be legally determined as lawful or unlawful on the same basis. So if the occupation was not lawful at the beginning, or at least was unlawful the moment the threat had been neutralized, so accepting Israel's argument in 67, then it is an unlawful occupation as a matter of the international law on the use of force. Israel then somehow cannot get a right to defend itself against a threat that emanates from territory that it is already using force in respect of illegally. That makes no sense. That would be like saying, and I use the example in the blog post that Dalal kindly mentioned, that it would be like a situation of assuming that Russia's war in Ukraine is illegal, that somehow if Ukrainian resistance fighters went into territorial Russia and launched an attack that involved targeting civilians, that therefore Russia's illegal war in Ukraine would somehow then become lawful as a form of self-defense in response to that attack. That makes no sense. It's illegal. It's pre-existing as an illegal use of force. And that's why it's so problematic. One of the many reasons why it's so problematic to start the analysis in October in terms of not just the many issues, but including the question of the legality of Israel's use of force in Gaza, in the Palestinian Gaza Strip. And I wrote it down when I was listening to it this morning. I think it was Malcolm Shaw, or no, maybe it was the first, I've forgotten his name, the first person who was presenting for Israel this morning, who said, or maybe it was Malcolm, Israel was defending itself in a war it didn't start. That was interesting because they've given themselves away, right? They're saying that it's a war that started in October. Now, in other contexts, and in fact, there's some leaked memo that has been circulating where Israel has constructed a legal justification that says this is an ongoing armed conflict with Hamas and Islamic Jihad. It's not something that started in October. And in the international law on the use of force, there is one of the aspects of that legal debate, which arose in the context of the attacks on the US on 9/11, is indeed whether this can be understood as an ongoing situation of hostilities, of which, the attacks on 9/11 were just one, right? Because there had been previous attacks by Al-Qaeda on the US, the attacks on the USS Cole, the two embassies, or whether that was the initial attack. It's a similar idea, and it has consequences legally for the law on the use of force. So it's a confused narrative, and I think what might be significant about this case, and potentially what happens next month, although less so because Israel won't be there itself, although its proxies are there making submissions, is in flushing out this position and understanding where it's coming from. And I think it was also significant that Malcolm Shaw mentioned the Palestine mandate in that regard as well, right? That was somehow legally significant. Because it sounds eccentric, but one of the arguments is Gaza and the West Bank are not occupied because Israel was legally promised the entire land between the river and the sea in the Palestine Mandate, in the way it incorporated the Balfour Declaration, and Israel has an international legal entitlement to that land. Therefore, it isn't occupied on that basis. And that so there is actually, there's a Palestinian right to self-determination, but somehow entirely unconnected to any territory, right? It's a completely mad argument. So, but it's one of the arguments that are made. And these cases might help us to be able to flush out what are behind these vague statements, the vague assertion of self-defense, the vague concept of disputed territories, in a way that then requires Israel to justify the fundamentals. Why is it there? Why is it still there for over half a century? In those two, in Gaza, nobody asked Israel that question. Internationally, Israel is not asked that question.
Yeah.
And maybe these cases will flush out and require the legal justifications, and even find them wanting, in a way that can be helpful. And if I can maybe just finish on one other point, Dalal, which where in the tragic killing of Shirin Abu Akleh, I remember watching, I was actually in Palestine at the time, I was actually in Sheikh Jarrah at the time, and I was watching of course, as one does, to try and get some actual news on the subject, it was Al Jazeera. And Diana, you were being interviewed on Al Jazeera, and you said, what we have to remember is it was only possible for her to be killed because the soldiers were in Jenin in the first place. And when I heard you say that, it drove home the point that, and I understood you to be trying to make this point, that everyone is focusing on these incidents as particular excesses of authority. And obviously, genocide is the ultimate excess of state authority. And that's, of course, horrifically necessary to focus on. At the same time, it's also necessary never to forget, never to not also ask, why are they even there? Why were the soldiers in Jenin? Why is Israel, does Israel even have a military presence in Gaza that it can then use to perpetrate potentially genocide? And that more fundamental question also needs to be addressed, and is a legal question, and is a legal question of the international law of the use of force and the law of self-determination.
Wow. Wow. Thank you so much for that elaboration, so extensively understanding the connections between the different dots in history and the continuation. We started speaking of a continuum, but the continuation of what was already an illegal use of force, and how this particular legal question has not been addressed in many avenues. It's taking as the status quo, as something assumed to exist without questioning why. And this elaboration actually prompted a few things that I'm remembering from South Africa's oral arguments. And I'm gonna direct this to you, Diana. I think one of the particular quotes that touched me was that some might say that the very reputation of international law, its ability and willingness to bind and protect all people equally, hangs in the balance. Speaking of this case, obviously, we started out by the symbolic historical moment that we're in, but also in terms of its implications on international law, on this history of illegality that we have been living through. And what does it mean that we are finally before a tribunal that can actually give a binding decision on all of these issues? Because as Dr. Wilde mentioned, it's inevitable that they will be discussed.
You know, that's such an important question. And I would encourage people to read a very well written op-ed today by a Palestinian legal scholar, also a very good friend of mine, Nimr Sultani, in The Guardian today, where he exactly summarizes this point. The issue about the case wasn't just the case as we heard it, but over the course of the past 100 days, all of us here, you know, you, me, all of us here, we've all been standing sort of stunned and saying, there's a problem with the international system as we know it. If the international system can't protect the most vulnerable, the weakest elements of society, then there's something wrong with it. And here we are, we're looking at Gaza, which is the people of Gaza are stateless. They're primarily, 80% of them are refugees, that Israel turned them into refugees. And half of them are children. And so if we don't have a legal system that can put the brakes on a country that has made its genocidal intent very clear from day one, then there's a problem with the international legal system. And I and others, I mean, we've all talked about this. Anybody who's a lawyer always talks about how frail it is, how sometimes useless it is. But it's more than frail and useless. It's kind of problematic if there isn't a way to actually stop what Israel has been doing. And so this case wasn't just about highlighting and stopping Israel, but it's really shining a spotlight on the international legal system as we know it, and on the international political system as we know it as well. And this is, although this isn't a criminal trial, and we're not talking about that, but it's not just about Israel perpetrating genocide, but it's also about all of the people who have turned the other way over the course of the past 100 days. And there are many people to name. It's states, but it's also politicians individually. And we've also seen that there have been others who have aided and abetted it. Like we've seen that some members of the press have gone alongside Israel's arguments without ever stepping back and questioning, whoa, is this even right? I can tell you, for example, that at one point I was asked endless questions about Israel bombing Shifa. And, is it the command and control center? Is it this? And when they go into this minutia of whether it's the command and control center, which it's not, but then nobody actually steps back and says, whoa, why aren't we interrogating the Israelis about whether it's lawful or just or right to be bombing a hospital? And so this is what was this is the core of what we're seeing today, which is that this isn't just about South Africa and Israel. This isn't just about Palestine and Israel. This is about humanity. This is about the international system as we know it. And this case is shining a spotlight on that system, and it's shining a spotlight on all of the people who remained silent and who allowed this to go on for such a long period of time.
Thank you so much for that. It does seem from both your remarks and Dr. Wilde that people tend to get stuck into these like weeds of the detailed nuances of the issue and never stepping back and zooming out to see the full picture and ask the fundamental questions that are at the roots. Dr. Wilde, we spoke about the Balfour Declaration, the mandate system, all of the colonial history that has affected the moment that we are at today. And I want to refer to another article you wrote a few years back, using the master's tools to dismantle the master's house, international law and Palestinian liberation. We usually hear the opposite, that the master's tool will never dismantle the master's house. And in light of that, many view the ICJ as a colonial institution, and that true South Africa brought this case and it has a symbolical momentous and could move the needle and is a much needed move, an applauded one. But we shouldn't glamorize the court's effectiveness or put it on a pedestal. What do you think of this? Is this case before the ICJ a scenario where we may be able to successfully use the master's tools per the title of your article? Sorry, I put you on the spot with that article.
So it's very difficult for me to answer that because of my positionality.
No worries.
And I should also say that I use that phrase in the title of the article, but I very much use the full quote by Audre Lorde in the article itself, right? The article is about the limits, but then in the article I say, as ostensibly an expert, these are the limits. This is what international law provides. This is what it doesn't provide. So, for example, the way in which international law fundamentally frames the situation on the basis of Israel's statehood and the fact, therefore, that the horizons for Palestinian self-determination understood in that context somehow have to fit around statehood and the obvious limitations and problems with that, right? And these proceedings, let's not forget, are only happening because Israel is a state. Israel can be sued before the International Court of Justice through its interstate jurisdiction because of Israeli statehood, right? So already with the assumption within this remedy has already affirmed Israeli statehood, which is something that people would, in other contexts, wish to contest, would wish to raise questions around the legitimacy of. And that's embedded in any legal strategy that calls upon Israel to comply with international law and calls it out for violating international law. It is not for me to decide whether that's, in all things considered, a politically meritorious approach.
I appreciate you. I'm going to end with a question to Diana, because I want to highlight this counter argument that Israel tried to pose today. You spoke about the numerous genocidal statements that we've heard throughout the past almost 100 days, and Dr. Quigley also alluded to this in the beginning. It seems that Israel completely ignored South Africa's reference to the 500 plus citations. And I know for the fact that Law for Palestine has supplemented the South African legal team with a database of more than 500 genocidal statements by people who, most of them are directly related to the war cabinet. And so this Israeli rhetoric or counter argument that this is war rhetoric, or that these come from politicians or the public, and there's a protected freedom of speech. And also I note that they alluded to this idea that they have a robust, independent legal system that can prosecute these people who are inciting genocide. So it seems that it was kind of invoking complementarity, which is we have witnessed in the ICC, but not the ICJ. Could you offer remarks on how that is going to ship out at the end?
Where do I begin? I live in Palestine, and there isn't a day that goes by, and I say this knowing that this is without exaggeration, really. There isn't a day that goes by without hearing some genocidal statement. Not a day. Whether that statement is by the president of the country, whether it's by the prime minister, and I'm not quite sure how you disaggregate the prime minister and the president and the minister of defense and the minister of finance and the minister of national security from the war cabinet, because they are part of them. You just hear this every day. So it's whether it's the president, the prime minister, the various ministers, politicians, and then it goes down even further to individual soldiers, to like commanding officers, to then soldiers, to then members of the media. And the soldiers are operating with this total sense of impunity. And because they're operating with this sense of impunity, they can do whatever they want. They can say whatever they want. There has not been an order that says, hey, don't make genocidal statements. Hey, if you make these genocidal statements, we're going to throw you in prison. Quite the opposite. The only people who've been thrown in prison are Palestinians for Facebook posts, for social media posts, for liking pictures on social media. So it's a system that only works when the person who is liking things is Palestinian. But if the person who is expressing genocidal statements, and believe me, we hear it every day, each and every day. There's no way you would have gathered 500 statements if it's not every day. They never get prosecuted. But more importantly than that, there is a responsibility for them not to say it. But Israel operates with such a level of impunity that it's that they think that they could do whatever they want. And there's something else that's really important in this. Look, and this ties back to South Africa. During the apartheid era, there was a statement, there was a common refrain that the apartheid regime used to use. And they would say things like, only South Africa, I'm going to add the word apartheid, only apartheid South Africa can stand in judgment of South Africa. That was their common refrain. And what we heard today was that exact same refrain. Only Israel, apartheid Israel, can stand in judgment of apartheid Israel. And so it's this like totally bizarro thing that they're so emboldened by what they do that they think that it's just commonplace to make these statements, because it is commonplace for them to make these statements. And they don't expect that anybody is ever going to hold them to it. But they do want to show Israeli society exactly what it is that they mean. And they do want to wipe us off the map. It's just that simple. If they didn't, they'd be prosecuting people. If they didn't believe it, they wouldn't say it. And again, this isn't in the heat of war. This is a man who stands up in front of a broadcast with written notes, who repeats and repeats and repeats these statements. And an Israeli president who's done the same, who also, by the way, the other day signed his name to a missile that we know is going to kill some kids. We know it. That's just, the statistics are that more likely than not, it's going to kill a kid.
Yeah.
And so that's Israel. That's Israel.
Wow. Thank you so much, both of you. We are at the end of our session. I wish we could stay all day. I think we can continue all day with the amount of things to talk about and unpack. I'm so honored that you joined me today. I also want to thank our interpreters who are translating this to Arabic, Malik, Dirania, and Noor Haqqi. The recording will be available in both Arabic and English by tonight on our social media platforms, Law for Palestine. Thank you for everyone who tuned in, and hopefully it was a fruitful discussion for you to listen to. Thank you. Bye.
Thank you.